Hello, everyone. Good morning, good afternoon. My name is Ismail Shahtakhtinsk, and I'm the founder and principal attorney at I.S.Law Firm. So, this is our next live session video about the news and immigration laws in the United States. And I will try to go over and comment some of the news and then answer as many questions as we can within the next hour or so. So the first news, well, before we continue, I forgot to ask you, please do like this video and comment and subscribe to our channel. It will help to, have you followed with the next videos. We have live session that will be next week, I believe, the on the 16th, the next Thursday. We try to make these videos once a week, these live sessions, question answers. So next Thursday we will have a live stream on where I will discuss the methods of the ways to immigrate into the United States through business for small business owners or large business owners, or through other types of visas through business. And also I will explain how one, even before coming to the US, can register a business in the United States and own a business in the United States, even if they don't have a work visa, if they are not allowed to be employed in the US, how they can lawfully own the business in the United States, and what we can do to help. So that will be next Thursday. It will be next Thursday, and I believe it will be same time, or let me look. So that will be at 11 a.m. Correct. So the same time, 11 a.m. Eastern time, Washington, D.C. time, next Thursday, we will talk about business immigration into the U.S. through business. But for now, I want to comment on several questions, news that came out today. Well, the primary news that I wanted to comment on is that there is information about Biden administration possibly reinstating family detentions at the border. What it means is that once asylum applicants arrive at the U.S. border with Mexico, and then they are requesting asylum without having a visa or permanent resident card, then under Trump administration, they used to be detained and put in detention centers. Under Biden administration, this was canceled. They were all allowed to enter the U.S. either with ankle monitors, bracelets, or they were, paroled into the U.S. and were asked, or required to check in with the Immigration and Customs Enforcement. Then what Biden administration did next is they came up with the CBP-1 app, which allows the border arrivals before arriving at the border to register with the Customs and Border Patrol, and make an appointment so that they can safely enter the U.S., go through the check process, and then they're not going to be detained. So that part of it was it's currently going on. You can download that CBP-1 app while you're in Mexico. Don't try it overseas. That's not going to work. But then once you're in Mexico, then you can download this and make an appointment and enter the United States. So nobody gets detained as long as they go through that process at this time. However, there are news that the Biden administration is weighing. Actually, during the White House press conference, also it was said that they're considering reinstating the family detentions at the border. And the reason why they have to do it, and at least the administration is saying they have to do it, or they're considering to do it, or I believe why they would have to do it, is because there is still considerable flow of immigrants through the southern border who do not go through the safer process, which is the CBP-1 process. And they're trying to enter the United States through the process where the Customs and Border Patrol don't know who this person is, who's this family, why are they here, and that's why they may have to reinstate the detention process. Now, the process of detaining immigrants at the border puts substantial strain on the U.S. law enforcement, and obviously, it requires a lot of taxpayer money to be able to pay for the expenses associated with the detention and with keeping those immigrants there. And then not everybody has a sponsor in the United States who may be willing to provide financial support. So those detention centers may be again overflowed with the number of detainees. So this is all concerning, and that's what they're weighing. They're not saying they're going to do it, but they're considering to do it. Maybe to push everyone towards going through the CBP-1 app, but CBP-1 app also is something that is not going to stay forever. So if you know someone, or if you are an asylum applicant and you're planning to thinking about coming to the United States to apply for asylum, considering that there is this CBP-1 app which creates the safe pathway for you to apply for asylum in the US and to arrive in the US, you should do it now, and you should consider applying now. Okay, don't delay it, because the CBP-1 app is not going to stay forever. The ultimate goal is to reinforce the borders so that the applicants, the immigrants, don't cross the border illegally, whether they jump over the fence or dig under the fence or whatever they do, or cross the river and so on. So the goal is to prevent that from happening. That's why they have CBP-1, which is a safer processing. People don't die, and law enforcement money is not spent to prevent people from illegally entering the United States. So the Biden administration is considering it. And one other reason why the Biden administration is considering, again, detaining the families at the border is because the Title 42 is going to be soon should end. It should expire in May. And it's not expected that the Supreme Court will or anybody else will be able to extend it anymore. So in May, the Title 42 will expire, which means that what was Title 42 was something under Trump administration. The government, and I believe, and many believe, used COVID-19 as a pretext to be able to bounce the asylum applicants off the border without even considering their asylum applications or basis for them. Under certain exceptions, which the federal court said the Title 42 was actually confirmed by the federal courts, by the Supreme Court, and the Biden administration couldn't cancel it, so it had to expire. It was related to the pandemic, as if somebody who's coming here could pose danger to the U.S. society, to people of the United States because of the pandemic. That's why they could be bounced off the border. Now that is set to expire in May, and it's expected that it will significantly increase the number of potential immigrants and applicants, asylum applicants, who arrive at the southern border. And that's why the Biden administration is considering those things. Part of also what, these news come out that the Biden administration is considering this and that, may be intentional disinformation, and not in a harmful way, but in a way to kind of deter those who are thinking just to come here for economic reasons, or just to cross the border, or come and apply frivolously for asylum. So maybe when these news spread and there is this conversation about it, people kind of feel like it's not that easy to just arrive in the US, get a CBP-1 app, and cross the border. So that could be also part of it. I don't think, if you ask me personally, I don't think that Biden administration is going to reinstate the Trump administration's policy of detaining, family units at the border. I just personally don't think so, considering that they came up with CBP-1, which is in a way of, almost allowing everybody to come in with a small background check. Well, they're saying that it's very extensive. It probably is, or we don't know what happens in the background, how they verify through CBP-1. But anyway, so I wanted to comment on that. Then the next news, or I would say rumors, are about the DACA, deferred action for childhood arrivals. Those are dreamers. Those are children who were brought in the United States when they were young, and now they're in here. There's, over 1.9 million or 6 million of those, of which about 600,000 have received DACA, which allows them to stay here, be employed, and not hide from the immigration authorities. So they're kind of lawfully allowed to stay in the US, but they may still have bars from becoming permanent residents or citizens down the road. So there are rumors that this DACA may be canceled, that Biden administration is considering that. That's not true. I don't think Biden administration would ever cancel DACA, or in general, Democrats would ever cancel DACA, or at least, our Congress would or Senate would agree to cancel it, unless they come up with a comprehensive immigration law for, a bill for dreamers, for those DACA recipients, so to open a pathway for them to become permanent residents and then citizens down the road. So, my comments on these news are, those news are not those, the news on DACA are just rumors at that point. They're not serious. And DREAM Act, unfortunately, is not going to happen anytime soon. I wouldn't hold my breath, but DACA, as long as those children, or adults now, but who were brought here as children, they haven't violated the laws, they haven't committed serious crimes, and they, then they can qualify and they can remain employed and be able to remain in the United States. Okay, so let me go through some of the questions. As much as we can during this time, and please post your questions in the chat section. Some of the questions are posted by admin because those are the questions that were either anonymously asked or asked prior to this through other, comments, I guess, under this video announcement. So you can post your questions in the chat section. I will do my best to answer as much as I can today, now, during this video session. And if you have any follow-up questions, or if you have questions after this live session is over, this video will be posted on our social media and on our YouTube channel. So you can comment underneath it. We'll try to answer as much questions as possible down the road as well in the comments. And as I said, please like this video and subscribe to our channel. All right, so let's jump into the questions. So the first one is posted by admin. Hello, please, I want to seek for asylum because of too much ritual killing of albinos in Africa. I have 2 albino children, and one of them was almost attacked, so I can get asylum in the USA. I'm sorry to hear about what you're going through and the risk to your 2 albino children, and I understand, and unfortunately that happens. There are some superstitious beliefs in some parts of the country, of the world, that albinos are either, some bring some kind of bad luck to the people. But anyway, so your children may, and you may qualify for asylum based on particular membership in a particular social group. I think it's immutable characteristics, and I think that they can qualify for asylum. The challenge you have is you need to be physically present in the US or at the US border to be able to apply for asylum. So, I cannot tell you what to do to arrive in Mexico, or how to do it, or what needs to be done for you to be able to take your children and fly to Mexico or Canada to arrive to the US border. But that's basically what you will need to do, or you will need to somehow end up in the United States to be able to apply for asylum. All right, I came to the USA with the visitor visa. Then I applied for asylum case after 5 years and no interview come in between. I married USA citizen. Then USA has given me 2-year green card. Then I withdraw my asylum case. My question is, can I go back to country and go back to USA? Any conscience? Okay, so I guess the question is any issues. So it's a very popular scenario for asylum applicants file for asylum. And the reason it's popular is because once the asylum application is filed, as we know, some of them and most of the asylum applications last for many years until the interview is scheduled. And people go through changes in their lives. They meet someone, they get married, or they have children in the United States who now grow up and they can sponsor them. So one way or another, or sometimes they find an employer who's willing to sponsor them. One way or another, they become permanent residents through other means. Now, there is a misunderstanding or misinformation by people who don't understand the laws, or by the lawyers or paralegals who don't understand or hear things and they misinterpret it, that you need to withdraw your asylum application for you to be able to apply for permanent residency, for green card through marriage or so on. And that's not true. That's wrong. That's actually bad. Don't do it, because it can create a question. Maybe your asylum application was frivolous, because once you apply for a green card, you're not getting the protections that the asylum provides you. Green card is just simply allows you, it's a card which allows you to live in the US. It doesn't protect you. You're still citizen of the country from which you at one point claimed asylum. So the United States is not providing any protection. I mean, the most famous unfortunate story is, we all know about the Saudi Arabian journalist who was killed by the Saudi Arabian government in Turkey at the Saudi Arabian consulate in Turkey. He was a permanent resident, Jamal Khashoggi, and Trump said, "What can we do about it?" He was a permanent resident. He's not a U.S. citizen, and there are no guarantees or protections provided to permanent residents in terms of similar to citizens or even to refugees. So and then nothing, right? So Trump still went and shook hands with the Saudi prince who did this. So I guess what I'm trying to say is that permanent residency doesn't give you those protections. That's also another reason why you should apply for citizenship as soon as you can, so that you have protections of the United States that citizens enjoy. But the green card doesn't. No, to answer this, I went too far now. To answer this question of this person, yes, even if you withdraw your asylum application, once you become a permanent resident, again, you don't have to. You can still get asylum while you're a permanent resident. But even if you withdraw, you're not basically, making it disappear. You're not changing the history. Your asylum application is still there. It's an under oath statement from you saying that if I go back to my country, blah, blah, blah will happen to me. Now, just because you got a green card and withdrew your asylum application, it doesn't erase from your history. So if you go back to your country with your current green card, down the road, a diligent USCIS officer, when you apply for citizenship, can come up with that question and say, well, was your asylum application frivolous? Of course, you're going to say no. Then they're going to say, okay, you applied for asylum. You said that, I'll be killed or arrested or imprisoned if I return to my country. But as soon as you get married with a U.S. citizen and get your green card, now magically you're safe to go back to your country. So the short answer is, if you travel to your home country after you get asylum or withdraw your asylum, you don't automatically lose. You don't automatically become inadmissible for misrepresentation, but it will raise questions. It will raise questions. So, make sure you're prepared for those questions. Okay, that's all I can say. And preferably don't travel there if your asylum case was not frivolous, it was legitimate, it was truth, it was genuine, then you're also running a risk traveling to your home country as a permanent resident, because again, you're still citizen of that country. The US doesn't promise any protections to you as a permanent resident. It just lets you stay here and work here in the US and live in the US. Okay, so all right, so the next question is, my wife has been in the Philippines for over a year. We just heard you can be outside. Yes, more than 6 months. Now, how can she come back? So I guess it's a permanent resident who's been outside of the US for more than a year. And they just heard that you cannot be more than 6 months outside of the US. So there needs to be some clarity. I never like to give just simple answer just because I know something you don't know. I like to explain to you so that you listeners can answer a lot of your own questions down the road. So I want to first explain, by answering this question, I want to first explain what is that 6 months thing when you have a green card. So if you have a green card, that's called lawful permanent residency. So if you're a permanent resident in the US, so naturally by the name of it, you have to be permanently residing in the US. If you don't, then you can lose your green card, okay? Because that's permanent residency. So you have to be a permanent resident in the United States so that you don't lose your permanent residency. That just logically the name tells you so. But how do they decide whether you're a permanent resident or not, whether you abandoned your permanent residence in the United States? They look at different things. So when you travel outside of the US and you return, even if you leave for 1 day with your green card, when you return, the CBP officer, the immigration officer at the border will ask you, what was the purpose of your travel, right? And you need to answer, otherwise they may not let you in. So, or maybe detaining you for additional questioning. So you need to answer. And if you naively or by mistake tell them, oh, because I live in, Bangladesh and I was just coming to the US because, I have children here, that's it. You just told the officer that you live there and you're coming to the US to visit, right? Just by that word, even 1 day absence, they can take away your green card, call you to immigration court, and put you in removal proceedings. So, to take away your permanent residence in the US because you just told the officer you're not a permanent resident in the US. You abandoned it, right? So, but nobody does that in realistically. I mean, probably some do, but most of the people wouldn't say anything like this. But how can they read one's mind? So they have to know whether they abandoned or not. So they have this rule that if somebody has been outside of the United States for too long, then we will presume that this person abandoned their intent of permanently living in the United States, right? If a permanent resident leaves the US and spends too long outside of the US, or spends too much time, too frequently travels, then we will presume that they abandoned their permanent residency. So they had to come up with some kind of regulation, some kind of instruction to the CBP officers saying, if A, then you should do B. If it's Y, then you should do this. So that's why they said, the policy came out saying that if somebody is, the law came out, the regulation came out saying that if a permanent resident is absent from US for 6 months or more, 180 days or more during a single trip, then you should presume, the CBP officer should presume that this person abandoned their permanent residency in the United States. If they spend more than up to 12 months, so between 6 months and up to 12 months, they can still overcome that presumption by demonstrating evidence of their good faith, connections to the US, or demonstrating the reasons why they were absent from the United States during that time. So, it could be like medical records, or you want to show your close ties. So that's why I always recommend green card holders, no matter how long they're going to be outside of the US, to travel with a file where they have tax returns, which is number one evidence. Okay, so if you have a permanent resident of the United States, go back and file all your tax. Get a CPA, get an accountant, get your tax returns filed, even if it's zero tax return. You don't have any income, you had income abroad, you may not have to pay any taxes because of the double taxation treaty. But if you're a green card holder, if you're a permanent resident, you must file tax returns. Again, even if it's zero tax return, if it's zero tax return, now somebody may say, oh, he's wrong. If it's zero, you must not file it. You can provide a letter from CPA confirming that you didn't have to file the tax return. Yeah, but that's more difficult than just getting the tax return filed. Plus, it will be something that is going to raise additional questions. So just get tax returns filed, okay? If you're a permanent resident, get your tax returns filed for all the years that you've been a permanent resident. So anyway, so those tax returns are something that you would put in that file. Then in that file, you also want to put your bank statements. If you have a bank account here, your driver's license, copies of your, bills, utility bills, letters from relatives, people that you live with when you come to the United States. Any other things showing, Costco card, store credit cards, memberships, things that you do in the United States when you live here, and the evidence why you've been absent from US. So for example, if you have an employment there, a job contract, make sure you get a letter from the employer abroad showing that you're working there. We had a client who was absent for quite some time. We used his receipt from storage, which stored his furniture when he sold his house and so on and left outside of the US. So we showed it that this shows that he didn't sell his furniture because he was intending to still return to the US. So that's the issue your wife is going to run into, is that now she hasn't been more than 6 months she's been more than 6 months. It's not up to, I don't know why camera is moving back and forth. Let me turn off this auto adjust tracking. Okay, good. So what I was saying is your wife. Yeah, so your wife been absent for more than 1 year, but she can still prevent that if she can demonstrate the reasons. During the pandemic, the Customs and Border Patrol officers were, told to be as flexible as possible because a lot of people remained outside of the US during the pandemic. So even if she overcomes that 1 year issue, so despite being 1 year, usually upon 1 year absence of US, they'll take away the green card. And I want to explain the process also, the risk also. It's not that they're not going to allow your wife to enter the US. They must allow. So the Customs and Border Patrol cannot just say that you've been absent from US for too long, that's why we're not letting you in, even though you're a permanent resident. No, they have to let you in. But what they're going to do is they'll process, they'll question, and then they can take away her green card, and they can give her a summons to appear in immigration court to explain to the immigration judge why they shouldn't lose their permanent residency and how come they've been absent for so long, even though they intended to maintain permanent residence. And again, you can be creative on finding evidence of her intent to be permanent resident in the US. And if you're a permanent resident and this is your wife, your presence in the US also helps as evidence, and you can provide testimony as to that. Okay. So I hope this answers your question, but the most important advice I'll give you is get a lawyer, consult a lawyer, and prepare for this so that your wife doesn't lose her permanent residency for good. Okay, so how long it takes the green card to replace? Because my green card is 7 months now for replacement. My daughter applied for my green card in November 2019 and just got my green card last year. I don't understand this question. How long the green card to replace takes about, I-90 is the form and it takes too long, but once you file, it automatically extends your green card. So, but the rest of the question is not clear. They're saying they just got the green card and then daughter has a green card. Anyway, I'll move on to the next question. July 2022. But my last name was wrong. Oh, okay, that's a continuation of the question. I'm sorry. So got my green card July, but last name, that's why they make a replacement. I'm 71, I want to visit my home, relax and come back. I'm here for almost 4 years. Okay, so you have your green card. It was just your name was misspelled and you filed for replacement of your green card and you're asking how long it will take. It will take a lot, but your filing of your renewal or replacement of your green card is the receipt, and you still have your old green card. So with that, you can travel in and out of the country. You're still a permanent resident, so that should not stop you from being able to travel. You can still travel. All right. So you say asylum, new rule, no asylum, Indian, May 2020. No, there is no such a thing. There is no asylum for India. How long it takes for Form F-129 processing? There is no Form F-129. There's I-129F, which is fiancé visa processing. So I assume somebody who's willing to, who's sponsoring a fiancé is asking this question. Depends. It takes, if everything is done correctly, in our experience recently, it's been about 8 to 10 months or more for the visa petition, and then you have consular processing. The consulates have been significantly delayed in processing these cases due to the pandemic, so it may take 1.5 years or so. Okay, I have a work permit expiring in 6 months. how soon do I go about for renewal? You can file for renewal of your work permit 6 months ahead. So you can file it now if it's within 6 months. Asylum seeker with work permit and SSN without green card, quality to buy a home. Yes, everybody can buy quality. Everybody can buy a home. You don't even have to be in the United States to buy a home. There are no restrictions unless you're person sanctioned by the U.S. government. You can even be abroad and buy a house in the United States. You don't have to be lawful status or social security number or anything. The challenge you may have is with the bank, who's, if you're going to be applying for a loan, the bank may not be willing to loan you money because you're not a permanent resident in the United States, or you don't have social security number, or whatever that might be. But it's between you and the bank. It's a private, entity, and as long as you have money or get a loan, you can buy a home or any property or open a business. Just want to be clear about it. So everybody can open a business in the United States. Again, as I said, on March 16th, next Thursday at 11 a.m., we're going to have a live session on immigrating into the United States through business, and how to open a business, how to own a business in the United States, even if you don't have a social security number. But just want to tell you all ahead of time, there is no such a thing as immigrating just because you bought a property. So, I know there are scams, there are, organizations, groups, or people claiming that if you buy a house in Florida, you can get a green card. There is no such a thing. Even if your house costs $10 million, you're not going to get a permanent residency just because you bought a property in the United States. If you open a business in the United States, you can. Green card or E2 visa, bring your family. And we're going to talk about this on next Thursday, 16th at 11 a.m. Washington, D.C. time. So please join our channel, click like, and subscribe to our channel. But let's move on to the next question. Okay. I have a work permit expired. Okay, I did read this one. All right. Is asylum seeker, okay, this one, the next one. Can I get a court date for individual hearing before I submit asylum application in immigration court? I already had the master calendar hearing. Well, number one, what's alarming to me is that you're asking this question, you're in immigration court, and you don't have an immigration lawyer. If you had an immigration lawyer, you wouldn't be asking this question. And if your case is in immigration court and you don't have an immigration lawyer handling your case, you are jumping off the cliff, my friend. So don't do it. Okay, that's my number one advice. This is a question that you're asking is very alarming. No, you cannot get an individual. You can possibly, if the judge overlooks and doesn't notice and schedules it, but you're going to run into issues. You have too many things. First, number one, you don't have, you have deadline for asylum application that you need to watch out for. How you prepare your asylum application. Every single word, everything you write there or provide will be scrutinized and reviewed, and will be, as you'll probably hear in the movies, will be used against you or can be used against you. So the same thing here, that you're going to be chewed up by the government attorney, by the prosecutor in immigration court, and you're risking a lot. So get a lawyer for your asylum case and handle. But no, usually the immigration judges don't schedule individual hearings until you have your asylum application filed, because they want to make sure that you do have that application filed. Otherwise, they're wasting time in your calendar because you may never file it, or you just may, abscond and not show up in court. So yeah, don't do it. All right. What is the difference between J1 and F1 visa? J1 is a cultural exchange program. There are different types of cultural exchange programs. F1 is a student visa. So cultural exchange programs may be practical, like employment exchange. For example, we hear of doctors or some researchers or scientists being brought. And the exchange program, what it means is it's exchange between the two countries. So it's based on the treaties between the United States and other countries, where they agree that, okay, they're going to send, students or, their professionals who want to, get some kind of qualifications in the US or learn the way things are done here, and then back and forth United States can send to those countries from us, from our students or professionals. So that's what J1 is. Now, J1s, there are different kinds of J1s. There is a work and travel summer program. If you go to any of the resort cities or resorts in the United States during the summertime, you probably have a lot of students from abroad who are working in the shops and stores and restaurants. Those are J1 students who come here for summer work and travel. What they do is they're allowed to work because of the seasonal shortage of the employees. The United States is interested to bring them here, and it helps to culturally get those people to know the United States. It may sound funny why we need to do it, but there is a lot of misinformation about the United States, and probably there's some misinformation in the United States about people in the other countries, right? Some people in the United States think that people in Iran or some other countries in the world hate Americans, which is not true. So it helps. Now there is no cultural exchange program with Iran. I want to be clear on this. But what I'm saying is, cultural exchange program, for example, with Russia, right? So the Russians are now brainwashed to believe in Russia that Americans are evils. They want to kill them and so on. So cultural exchange program helps to bring those people here, get to know, what America is about, and maybe, increase the influence of the United States, or just to bring peace between the world, between the countries. So it's kind of like policies. That's what the cultural exchange program is. So sometimes they send those work and travel. Sometimes it's a school program. Sometimes it is a work program for a doctor, professional, research scientist, or work, come to the US and actually work in the US for some time, get some skills and knowledge, and then go back and apply in their country. But there is also some caveat. There is also catch with J1 programs. Not all of them. There is also au pair, for example. You heard of the probably nannies being brought into the US to allow them to go to some kind of school here and work as nanny in the families. Those are called au pairs. The au pairs in work and travel, you usually don't have the 2-year foreign residency requirement, but every other J1 usually does, with some exceptions. And if the J1 program is sponsored by the U.S. government, State Department, USAID, or any other agency of the U.S. government, then you definitely have that 2-year foreign residency requirement. Or if it's sponsored by your government, then it also has definitely 2-year foreign residency requirement, which is really hard to get waived sometimes. F1 is just a private student visa. You apply to school, get it enrolled in the school program, then apply for F1 visa. Then you can come to the US. Your family members can be F2s, derivatives also be present in the US. And it doesn't have those restrictions of 2-year foreign residency, meaning you don't have to go back and live 2 years before you can apply for permanent residency or work visa or so on. J1 has those restrictions, so be careful. All right, hello, can I apply for a visa for a family member who is not a US citizen or permanent resident? Yeah, of course. Well, okay, for a family member, can I apply for a visa for a man who is not, meaning you are not a US citizen or permanent resident? Yeah, if you're not a US citizen or permanent resident, you don't file for a visa for family member. They file for a visa. You can provide supporting documentation or evidence or letter saying, hey, I'm here, they're going to come and visit me, I'll make sure they leave on time, and we're going to do this. Be as specific. So you can help them with their visitor visa process, but there is no application that you file for them. Can I work for multiple employers on a single visa? Yes. Well, depends on what type of visa. But yes, what I mean is, if you're referring to single visa, meaning work visa, H-1B, well, you don't work on visa. Okay, the camera started doing this again. So let me turn this tracking off. Okay, so you don't work on visa, you work on status. So depending on your status, if you have H-1B status, it's tied to one employer. If you have E2 investment visa status, it's tied to your employment, to your business. Or if you're E2 employee, then to your employer. But you can have multiple H-1Bs, for example. So you can have, part-time employment with one H-1B employer and the part-time with another H-1B employer. So it's not a yes or no answer. You need more information, or for me to be able to answer you, I need more information about you or the type of visa you're referring to. Okay, can a dependable wife travel to her home country? What does dependable wife mean? I guess dependent wife. Okay, meaning derivative. Okay, travel home country while asylum is granted. So the question is, if the family is granted asylum, there is a principal applicant, spouse who was the principal who applied for asylum because they feared persecution in their home country. And in this case, I think they're talking about Russia. So, for example, a principal applicant is is a positional figure, or somebody who's just doesn't like Putin's government and opposes it, and they are being conscribed to the army, and they don't want to serve. Anyway, they got asylum, and let's say their wife is here with them. Can the wife go back to Russia? The answer is typically yes, because the wife didn't claim that she would be subject to persecution in Russia. So there is no question as to why she went there, unless in your asylum story, in your asylum process, you also claimed, or your wife claimed, that she also suffered persecution, or it was so intertwined in your family, was intertwined in your case. Then there is a reasonable question, is that you said that your family was threatened because of your political activities or disagreement with the government. Then how come your family went back once they got asylum? But to be clear, when you get asylum, you're also not barred or completely banned from being able to travel to your country. Okay, that's also misunderstanding or misinformation, or people don't know what they're talking about. When you get asylum there's a printer turned on here. When you get asylum in the United States, you are claiming that you cannot return to your country. And then once you get your asylum, if you go back, then the question comes up. So you don't automatically lose asylum, even if you travel with your asylum or with your permanent residency. Now, once you get your asylum and you travel there, and you're using the passport of your country until you get travel. Well, your country is not going to let you, the citizen of that country, go with a travel document. But in any case, so it creates questions. It doesn't automatically make you lose your asylum. All right. Next. Now, my wife received her green card. Can she file I-130 with old removal order, or we should wait I-730? It has been 2 years. So yeah, if your wife has a removal order, you're talking about I-730 based on asylum and so on. I mean, get in touch with a lawyer. It's not a forum or live stream question. Okay, if your wife has a removal order, it needs to be reopened. The USCIS doesn't have jurisdiction to grant her asylum or I-130 or so. There has to be communication with immigration court, with the government attorney, maybe under prosecutorial discretion. Her removal case can be reopened, and the government can agree to terminate it, as long as you demonstrate bona fide relationship and approved I-130 or 730. These are the answers, but it's complicated. I mean, if you're asking this question here in the live stream, again, I try to give us detailed. I'm not hiding any information. I'm not enforcing. In fact, I'm not trying to push anybody to hire a lawyer. In fact, we want to make sure that less people contact us with the uncomplicated cases or hire us for those cases, because we're not interested to spend time on doing that. We would rather handle those cases where you actually need a lawyer, where you do, or some people just want to do it because they don't want to spend their time or risk any mistakes, or they don't want this anxiety or uncertainty. Just like if I need to change oil in my car or fix the motor in my car, I probably can learn how to do it, but it will take me a lot of time. I may make a mistake and then screw it up, and then it's not going to be good. So that's why also, hiring a lawyer. But this is a complicated case. You will have wife has a removal order, get a lawyer and talk to them and handle that. All right, last week you mentioned that it's possible to request an early asylum interview should there be an opening with USCIS. What is the process to request this? No, I did not mention that there is a process to request an early asylum interview. I mean, there is a process. Everybody can request an asylum interview. You can send a letter to asylum office. You can make inquiries. You can send an email. Every asylum office has emails. So the process is you send an email. What I was talking about, and it's more, you just have to pay closer attention, is that when you move from one state, for example, to another, your asylum office changes, or if you engage a new lawyer in your case, and that makes the USCIS officer to pull your file to look into it. Sometimes, not always, and much more or less now than it used to before, it triggers them, it allows them to take a look at your file, right? So, and especially if you are, you filed a naked asylum application maybe in the past, and that's one of the reasons why most of the cases get delayed, but not only the only reason. So most of the reason is backlog. But then, you now provided supplemental information, got your asylum case fully, supplemented. It's also a chance to tell the asylum office, hey, if you have a window, maybe schedule my asylum interview date for that time. So there are ways to send these notices or requests or emails, but of course it doesn't guarantee. That's not a set procedure. Otherwise, everybody would be doing that. Now, there is an expedite request, right? So that's a set procedure, but it has requirements, not just saying, hey, if you have a window, put my case in. This is actually saying, move everybody aside, let me go in first because my case is urgent, right? So that's what you need to understand with expedite request for everybody who is considering to file expedite request. Expedite request is a formal procedure where you're telling the USCIS that there are urgent humanitarian needs, and the urgent humanitarian needs have to relate to your case of expedite. What it means is that if you're saying you need to expedite this case because something is going on, you have to also show how expediting your case is going to solve that problem that is going on, right? So, somebody may have a very sick parent, right, abroad in their home country, and you're an asylum applicant. You're saying, oh, I have, dying father and mother. It's an unfortunate situation, but the USCIS is going to say, how me approving your case now or getting your asylum case interview forward is going to help prevent that happening. Or you're saying you cannot go back to that country. So if we give you asylum, you're not still going to be able to go there anyway. So why should we put your case forward? Just emotional, or sometimes we have clients saying, oh, I'm suffering psychological issues because of the uncertainty about my status in the US, that is this, and we understand you, but the problem is everybody does. So all of these hundreds of thousands of people standing in front of you in the same line are going through the same issues, right? They also want to get their asylum cases. Not all of them. Some of them just like to enjoy the ride and use their work permit, and maybe they're going to meet someone and build family and get asylum or get green card through other means. But most of the asylum applicants who have true basis for asylum, they want their cases heard faster, and everybody's on the same boat. So don't apply for expedite request unless you have really reasons and basis for expedite. And the expedite requests are also now backlogged, unfortunately, because of so many expedite requests. Anyway, they need to, that's why we need an immigration reform. That's why immigration offices and asylum offices need a lot more budgeting, reorganization, and so on, so that these backlogs can be cleared. Can I ask asylum at airport? Give me detailed info, please. Well, what is detailed info? I mean, you can apply for asylum as long as you're in the United States or at the US border. So if you're at the US airport and you come to the checkpoint, you can potentially apply for asylum. You'll be detained and you can apply for asylum. Can I ask asylum at airport while transiting? Give me detail. Okay, that's just the repeat question. Sir, I'm born in Pakistan. Can I apply for diversity visa program? Yes, as far as I Remember, Pakistan is not one of the excluded countries. Those countries which have more than 50,000 immigrants per year are excluded from DV lottery eligibility. Those are, usually the bordering countries, the Mexico, Canada, India, and so on. India is not bordering, but the number is significant. A number of immigrants per year is significant. That's why they're not included in diversity program. As the name of diversity visa suggests, diversity, it is for diversifying. It's not for bringing more of the immigrants from the same countries that are immigrating here anyways. So that's why they exclude. But I don't think Pakistan is there unless they included it. I don't do the lottery applications myself. That's why I'm not sure. But again, as I know, Pakistan is not included is not excluded from it. Last question, is it better? Okay, same person. Is it better to reopen BIA removal order with joint motion with DHS or sua sponte? Again, I'm not here to tell you how to do surgery on yourself, sir. So, people often ask me, can I consult with you and ask you how to fill out the form or answer the question in the form? I tell them, no, we attorneys are not ethically allowed. Legally, we're not allowed. We can lose license for telling you how to handle your own case. Now, we can give you the consultation, explain the process, or answer your questions about your eligibility, but we cannot tell you how to fill out the forms or legal advice as to which way it's better. Because number one, we don't have sufficient information about your case, right? So that's just logically improper for a professional to just give you a quick answer so you're satisfied, and then you go and make a mistake, then you ruin your life or your wife's life, and you get an order reinstated which you can never reopen, for example, right? Or she may be permanently barred from ever being admissible in the US. So it's for your sake not to rely. If I was an opportunistic or a lawyer who just brags about knowing everything, I would just give you an answer quickly. Let's say I did, but as a human being, I don't want you to rely on somebody giving you, even if it's experienced lawyer. You don't want to build your life in the United States based on just somebody giving you a quick answer, okay? You want to make sure that a doctor examines you before they do the surgery, that you do surgery on your own. So just like a doctor cannot teach you how to do a surgery, how to take a scalpel and cut yourself and fix yourself, you can do it. The law doesn't prohibit you from trying a surgery on yourself, okay? But nobody can teach you how to do it on yourself. That would be unauthorized practice of medicine. Similarly here, I cannot tell you what to do with your wife's case because that would be unauthorized practice of law. There is this bright difference between general information I can give, answers, general license I can give, versus those specific questions you're asking about motion to reopen, Board of Immigration Appeals case with DHS or not. It's just yeah. Anyway, I just want to be clear on this. It's sometimes I feel bad because some people do that. They gather these pieces of information here and there in forums, and then they end up in big troubles, and then they come back to us. They come back to me or to other immigration lawyers, to my colleagues, and we talk about this in American Immigration Lawyers Association. We have people that have been permanent residents for many, many years and end up losing permanent residency or placed in removal proceedings. Or we have people who will never be able to become permanent residents because they screwed up by doing things that they learned piece by piece, or they were misinformed, or had friends or somebody else fill out their forms. Look, USCIS is not going to give you slack because your friend or somebody else or a paralegal who was trying to help you filled out those forms for you. They're not. And if they find the misleading information, that's going to be held against you. You will be barred. You will become inadmissible because that's your form. These are your forms, the questions. And, unless you had a lawyer there who's going to state that, oh, it was my mistake under oath, there is also a process for that. You need to file a complaint. That lawyer may suffer for those mistakes, but you may come out of the situation by lawyer taking the blame, but nobody else. Okay, that doesn't work that way. So don't please have non-lawyers fill out your forms or give you advice where to answer yes, where to answer no. I mean, almost every week I deal with consulting with clients, people that consult with me, they're telling me, or somebody filled out the form for me, and then just by 2-3 questions, next questions, I figured out that there were some questions that were answered wrong, right? So they're risking about being interviewed or being caught in those wrong answers, and boom, that's inadmissibility. That can cause your case denied. That can cause your citizenship being pushed for 5 years down the road. Somebody who qualifies for citizenship today, they make a mistake in the forms, they indicate the wrong check mark, and they go and their citizenship gets denied, and they get pushed for another 5 years because of the lack of good moral character, because of that lying. So again, you may not be lying, but it's going to be held against you. So don't do it, please. Don't hire me, hire somebody else, but go get a lawyer. Okay, that's a complicated case. All right, asylum, family, new baby law, USA. I like that's almost like doing a Google search, with the way they're posting questions for me. Okay, I'll try to answer as AI. So I am interpreting this means that somebody filed for asylum, they got a new baby in the United States, the baby is a citizen, and there's a question mark. I assume that this person wants to know, what is this going to give them? Legally, it doesn't give you anything at this point. So if you have a baby in the United States, congratulations, and they are U.S. citizens, and make sure you get the birth certificate and their U.S. passport. But that baby can only sponsor you 21 years later, once they turn 21. So having a U.S. citizen baby in the United States, born in the U.S., is not going to give you anything at this time, unless you have a situation of, for example, cancellation of removal. Cancellation of removal is a benefit to which you can apply in immigration court, which will protect you from deportation, and it will give you end up with permanent residency if you have been in the U.S. present physically for 10 years or more before your case was sent to immigration court. And again, camera is tracking by itself. So cancellation of removal in immigration court. Oh, come on. Cancellation of removal in immigration court. Okay, it's not doing it now. 10 years physical presence in the U.S. You can have small, up to probably around 90 days or so, brief trips outside of the U.S. But those 10 years have to be in the United States before you were called to immigration court, before your either asylum case was referred to immigration court, or before they actually gave you the notice to appear in court. So 10 years of physical presence in the U.S., and you have to have a U.S. citizen, child, or wife, or both, or husband, and you need to demonstrate that your child or your wife or husband will suffer unusually extreme hardship. Not just extreme hardship, not substantial hardship, but unusually extreme hardship if you are not able to stay with them here in the United States. Okay, so those are the cancellation of removal. Having a U.S. citizen child can help you with that process. If you're in immigration court, go through that process. The next thing it can help you with is just the human factor when you apply for asylum. If you have a U.S. citizen child born here, an asylum officer or judge is considering your case, having close ties, parents, siblings, children in the United States helps just the human factor, right? So you're not, they know that eventually you're going to be sponsored and brought to the U.S. by this baby or one way or another. And it's also motivation for U.S. citizen child to be able to stay in the work in the U.S. Live in the U.S., go to school. So it's just the human factor, okay? But other than that, being giving birth to U.S. citizen, giving birth to a U.S. citizen in the U.S. doesn't automatically give you any immigration benefits. Okay. If is refugee visa denied, can I apply again? No, I mean refugee visa. You mean through UNHCR? I don't know. I don't handle and lawyers usually don't get involved in the IOM. So
through United Nations Program for Refugees. If you're talking about asylum, the asylum, no, it cannot be. You cannot reapply if your asylum was denied. Now, if it was denied by immigration court and then you did an appeal, or you appealed and the appeals were denied, all you can do is get reopened, apply to reopen those cases. Now, if the USCIS denied your asylum case, the only way they can deny your case instead of referring to immigration court is if you had a lawful status in the US. So if USCIS denied your case, then answer is yes, you can apply, but you don't hope for USCIS to now approve it unless something substantially changed. It's totally new reason or so on. But what the USCIS is going to do if they denied previously your case because you were in lawful status, but you're not, just procedurally you file for asylum again, but then they'll route it, they will refer it directly to immigration court. So you will have that chance with the immigration court. That's another thing that many people misinterpret. Many lawyers even don't understand this. And of course, there are lots of individuals who heard something and then they start telling everybody something that is wrong. Is that if you are in status like student status or work status or even between visas, visitor status, some people say you shouldn't apply for asylum yet. Wait for your status to expire so you apply, so that you'll have a second chance for asylum in case if the USCIS doesn't give it to you, your case will go to immigration court. But that's wrong. Yes, it will go to immigration court automatically. But if you apply while you're in status, you can still take your case to immigration court once you lose that status down the road. But the additional benefit you're going to get is that even before denying your status, the USCIS is going to give you one more chance. So, if you apply for asylum affirmatively, you get, in terms of arguing and convincing somebody that you deserve asylum, you get two main chances, right? You get affirmatively with the asylum officer and with the immigration judge. Now, if you apply, and then, there is appeal to BIA if the judge did wrong and so on, but that I'm not counting that. But if you apply for asylum while you're in status and you maintain your status, you're going to get three chances, because you're going to get, interviewed by the asylum officer who's going to consider it, make a decision. And if they don't want to give it to you, if they think that you have issues with your case, if you're in status, they will give you what's called notice of intent to deny. And they'll give you 30 days or more to let you answer, explain, and address those issues, okay? So that gives you this additional chance. Maybe the officer misunderstood something. Maybe some additional paper that you can provide to them can help. So you get that. And down the road, if you lose your F1, H1, or whatever status you have, then you still can get your case to immigration court and get the immigration judge to review your case and consider your case. And if not, you're still in status, at least you will have other ways of getting permanent residency. Even if USCIS denied you asylum, you're still in status. You can down the road apply from employment-based and so on, or and become permanent resident through that way. Versus you're now in immigration court, one step from removal order, and you're risking not being able to apply for any other benefit, except a marriage with a U.S. citizen, where it will still be strenuous process. You need to terminate your hearing, your immigration proceedings in court, and then apply through USCIS will take years, versus it wouldn't if you maintained your status. All right. Okay. Asylum, new baby in law. Is refugee visa denied? Apply again. Okay, that's why I answered. Hi, I think you skipped my question 1139. I'm sorry if I did, and I see that this is same person asking multiple questions, and I apologize. I cannot go back. Well, I don't think that's the same person. Okay, to be fair, let me go back and find it. Okay, based on green card time, can I apply for citizen, so I'll be able to petition for I-130 and also have 730 waiting for interview overseas? What is your advice? To be honest, I don't understand your question, sir. It says, based on green card waiting, can I apply for citizen, waiting for interview overseas? What is advice? I mean, what is advice? Advice to what? So If you have a spouse, you're willing to sponsor. If you're a citizen, you can file I-130. If you're a permanent resident, you can file I-130. If you have asylum, you can file I-730 within 2 years of your asylum grant. And that might be a better option if you want your wife to be also eligible for protections and benefits of asylum. Okay, the next question is, if I sue the government for waiting for asylum interview for 6 years, will it hurt my case? Nobody can tell you for sure it will or not. It's a human factor. I mean, I have never advised my asylum clients, and we have hundreds waiting for their interviews at any given time. And I've represented thousands probably throughout my career. But in terms of mandamus action, which is the lawsuit in federal court for asylum applicants, I don't recommend, but I have had clients who actually did that on their own, or somebody who came to me after the fact to represent them in immigration court. And I've had instances that their asylum cases were sent directly to immigration court. Now, they will never say that we did it because they filed a mandamus action, but unfortunately, that's what it looks like. So suing government for waiting for asylum case doesn't mean, even though you may get an order from the federal court to the USCIS saying that, or it may trigger usually the federal doesn't get there once you file that. The U.S. attorney in federal court, the federal attorney forces the USCIS, not forces, but communicates with the USCIS asylum division, and the asylum division pulls your file, and they decide to get rid of your case quick as possible because you're making problems for them. And they review your case. It doesn't mean they're going to deny it. It also doesn't mean that your case is going to be approved. So, it's just, it's possible that your case is going to be handled quickly. But the government also has arguments in those cases that, every asylum case is backlogged. The Congress didn't allocate enough budget for the asylum offices or the USCIS or DHS to be able to process all these cases. Why should your case be put ahead of others is the argument against it. But as I said, typically you get your case heard either faster or not, or referred to immigration court, even without interviews. That also happens. But there is no straight answer. There is no, rule or formula that I can give you or anyone can give you, should you file mandamus action or not. Now, I've filed mandamus actions in citizenship cases, and it works usually. But also in those types of cases, I always also tell my clients that you need to be sure that you have a bulletproof case. You want to make sure that your case is strong, that there is not much discretionary leeway for the officer to decide one way or another. Because if you sue federal government, it depends on the officer. Okay, somebody may be upset that you're suing them because they're doing their work and everybody's waiting in the long line with you. Okay, asylum, family name. Okay, that I answered. So my uncle's wife's immigrant visa is issued. Her husband died. Can she sponsor my father? My uncle's wife's immigrant visa is issued. Her husband died. Can she sponsor? No, she cannot sponsor your father, your uncle's wife. There is no such a process for filing a petition for that distant relative. Okay. Hello, sir. I want to know about address change. Is it mandatory for foreign fiance too? No, it's not. I don't think there is an address change process for foreign fiance during the fiance visa process. And at the time of their interview, they will get there. But, it's a good idea. It's advisable to notify. So to notify the consulate or the NVC at the second stage of the process. So you filed a petition with the USCIS. Now it's going through the second stage. And at that stage, you do the change. Now, will it hurt if the address change form, the AR11 you file online, if it takes that for the address, you can do it. It's not going to hurt. So, why not do it? It's going to take 10 minutes of your time. Our case was approved yesterday, and I have to go to India tomorrow. Okay, good. Oh, approved. Okay, the fiance. Okay, that's continuation of the next question. Of the same question. Yeah, if your case is approved, you have to go to India because you want to bring your fiance to the U.S. or travel together. That's fine. No, you don't have to make a change of address now. When she arrives in the U.S., she's going to be processed at the border, and she can file or notify that, or go online and file the change of address at this point. Or once she's here and you get married, then she's going to file adjustment of status, at which point you do that. Okay, all right, I think it's been enough. It's been 1 hour and 15 minutes. It's been a pleasure answering all these questions. Very good questions. Thank you so much for joining. And as I said, next week, next Thursday on the 16th, we're going to have a live session on business immigration, on immigrating into the United States through business ownership. I will clarify whether you can immigrate through buying a property in the United States, opening a business, how one can open and register business in the U.S. While not even being in the U.S. or not having a lawful status in the U.S. or a visa, or what kind of immigration benefits or visas you can get by the virtue of having a business in the United States. I'll also touch upon the business side of it too, not just the immigration side. So in terms of registering business, things to pay attention to, which state, and so on. So it's going to be a lot of good information, I promise. I will clarify all that, and that's going to be next week on the 16th, Thursday, at 11 a.m. Eastern time, which is Washington, D.C. time, which is where we are. Please like this video. Please subscribe to our channel so you're going to be notified about the upcoming live stream videos, and use this opportunity to ask you questions. It's almost like free consultations you're getting, and hopefully it's helpful, and I enjoy doing this. I will be doing it more, and see you guys next week. Thank you very much. Bye-bye.